Be seated. The court is now back in session. The floor is now given to the co-prosecutors and the lead co-lawyers to respond to the second question. As follows, the trial chamber's servant's order and related decisions were expressly motivated by a concern to preserve its ability to render any timely verdict in case 002. As a general matter, would you prefer the chamber to attempt to try a broader array of charges and factual allegations in case 002 at the risk of no verdict being ultimately obtained? Or do you consider it preferable to proceed instead in relation to a more limited array of charges and factual allegations, thereby increasing the likelihood that a verdict can be rendered? That is the question. The floor is now given to the co-prosecutors.
Thank you, Your Honours. Some level of repetition, I'm afraid, because these questions are so interlinked. Certainly, our position has been from the very start of this issue back in 2011 that we would wish for this case to proceed upon the basis of a more limited scope of charges for the reasons referred to in the first question. Our dispute with the Chamber is simply whether or not the particular charges selected in the severance order, the crime sites that were selected, are representative of the indictment of the closing order as a whole. And we say that those matters that you selected are not representative. And indeed, again, to repeat myself, if you go to the Supreme Court Chamber's decision, they agree with us. And they say that you have to address that issue in your new severance order. So, yes, we do agree that this case should proceed on a more limited array of charges and factual allegations, because we believe that that will increase the likelihood of a verdict. But we say that those matters that you select for the new severance order should have this reasonable representativeness quality. And I think you will guess that I am in favour of the second option that the Supreme Court Chamber gave you, which is the option that there will only be one trial, and thus you must ensure that that trial, again, to repeat myself, is reasonably representative of the case as a whole. One final comment, and then I've completed what I have to say on this. I heard earlier my colleague, the international lead co-lawyer for the civil parties, say that this is all very late. And I understand her frustration. It is very late in the day that this decision comes down. But it is a decision of the Supreme Court Chamber, and whether it's late or not, we, this court, the parties, have to follow the direction that is given in that decision. And also, I would emphasise to you, even though we follow these questions, it's absolutely imperative that the parties are all properly heard. That's what the Supreme Court Chamber stated. We have to be heard on these issues because it goes to the heart of this case. And these issues have to be resolved very, very quickly. We all know that, but we must all be properly heard. Thank you.
President, thank you. The floor is now given to the lead co-lawyers for civil party. Please make a direct response to the question. Thank you, Mr. President. To respond to the second question, the lead co-lawyers and the civil parties themselves would not like to have one trial covering all the facts in case 002. The civil parties would like a trial where a verdict can be issued, and of course, in the spirit of the severance of the case, it is a relief for the civil parties to see a shorter trial where a verdict could be possible. And of course, the trial should be proportionate to the actual situation of the health of the accused as well as the financial constraint faced by the court. My international colleague would like to add to what I just stated. The President, yes, you may do so.
Oui, je rassure.
I don't have a complementary point to make on each question, but here I would like to make a clarification. The Supreme Court decision is not too late because it raises questions that had not yet been dealt with. And as far as we're concerned, it is excellent that these things have come up again before this court. I was simply saying that it is tardy in the sense that it totally annuls the severance. That's not quite the same. On the second question that has been put to us by the Chamber, I would simply add a few thoughts because it obviously doesn't lend itself to a yes or no answer. It's not a simple case of alternatives. On the one side, a judgment within a reasonable time limit, and on the other, a wider scope of trial with the risk of no sentence. Obviously, it's not quite like that. You have to find a balance, and the balance has, of course, been adjusted as the discussions have proceeded. Two basic ideas on this subject I will share with the Chamber, which are necessary, I think, to make a decision. The first point is that if representativity relates to the choice of facts that you choose to bring up, then such representativity also relates to the way in which such facts are treated in the debate. What I mean by this is, as of the point in time when there has been severance and when we are limited to forced transfer 1 and 2, then we are limited to asking questions, submitting documents, and intervening by looking for the causes and the effects of the transfers, by connecting them with other events, with a view to giving meaning to this trial and to make, insofar as it is possible, a representative trial that ends within a reasonable time. We are therefore not obliged to include all of the facts for the trial to be representative. You simply have to include certain events and facts, and here we fully share the position of the co-prosecutors. We were not against severance, we were against severance as it was done. My second point, which I think is important, especially for respect for the civil parties, is that, as we have said before, as far as we're concerned, a trial is not a simple decision. The decision has to be rooted in debate, which gives it substance. In a trial such as this one, the completion of which depends on a great many rather random factors, we should not attach much greater importance to the final decision than to the discussions that lead to it. The latter is just as crucial as the final decision, and even if quite obviously our goal, as in any trial, is to reach a final sentence, everything that happens before in the trial proceedings is something that makes a positive contribution to the search for justice. Now, I wanted to point this out to you because the answer to question number 2 that we are being asked lies in a delicate balance between reasonable time limits and, at the same time, the representative nature of the trial as a whole. Thank you.
President, thank you. The floor is now once again given to the co-prosecutors and the lead co-lawyers. I'd like first to give the floor to Judge Fans. You may proceed.
I just wanted to highlight a factor relevant in this balancing exercise. I'm sure it's clear to the parties, so this is basically aimed at the public who should understand what we are doing here. We are talking about the likelihood of a verdict. A verdict needs to be written. The writing of a verdict can only start once evidentiary proceedings are finished. That means there will not be a verdict on the day after the closing speeches. Now, I will not speculate on the time needed for writing this verdict, but perhaps we can get some idea on the time possibly needed when we look at case 1. This was a case against one accused, dealing with basically one crime site. After the closing speeches, it took 8 months for the trial chamber to get the verdict out. Proceedings before the Supreme Court took another roughly 1.5 years. So if we add this, we arrive at, if I calculate it correctly, 2 years and 3 months to achieve a final verdict after the closing speeches. Now, this case is a case against 3 accused with arguably more evidentiary and legal challenges. The reason I'm mentioning it here is, first of all, transparency for the public, and secondly, but I'm sure this has happened already, to ensure that the parties take this factor into consideration in further arguments. Thank you.
President, thank you. I'd like to give the floor first to the co-prosecutors and then the lead co-lawyers to respond to the third question. And the third question is the following. At the time of the SCC decision, the trial chamber was nearing the conclusion of case 002/01. It estimates that relatively few additional courtroom days in the presence of all 3 accused were required in order to conclude the hearing of evidence in that first trial. Since the lodging of the co-prosecutor's appeal, and as foreseen by the medical experts periodically reviewing the fitness of all accused, the chamber has experienced increasing delay and difficulty in obtaining the presence of all 3 accused at any given time due to their physical frailty. In the light of these changed circumstances and difficulties of implementing an alternative course at this late stage, do you still oppose the trial chamber's definition of the scope of its first trial as expressed in the severance order and related decisions?
Thank you, Your Honour. Just to respond to Judge Fens, of course, Your Honour, we are aware of how long judgments take to write. We know that. But actually, in a way, you have, I think, reinforced the argument as to why this one and only trial should be reasonably representative. I mean, what you've said and certainly you'll hear our views on this later, you don't want me to talk about it now, we see it as an extremely problematic proposal to move to a second trial while you're still writing the first judgment. That's always been our position. So I think, in a sense, what you've said actually reinforces the position of the prosecutor that this first case does need to be reasonably representative. And if you're talking about months in terms of writing a judgment, we're talking about weeks in terms of hearing further evidence. So, yes, we accept what you're saying, but we believe it actually supports our position that this trial should be more representative, that we should follow the guidance, indeed we must follow the guidance that's given by the Supreme Court chamber. Now, in terms of answering this particular question, again, it's linked to the first two questions. We do not oppose severance, but we do, and we always have, opposed the scope of the severance order. And the reason for that goes back to what I said in the other two submissions, is that the case as it stands at the moment does not follow the international legal position, which is that the reduced case should, as far as possible, in the difficult circumstances that exist in this court, and I'll come to that, it should be reasonably representative of the entire closing order. And again, I know you want me to address this later on, but I'll say it now because it's linked. You can, of course, when you are considering that test, bear in mind the particular circumstances that exist in this case, that the accused are elderly, that they are frail. Indeed, in terms of our request, what we are going to ask for, we've taken that into account. You have to balance that. And indeed, the proposition that we are going to make to you is, we believe, in our submission, the best one in the circumstances, bearing in mind the particularly problematic circumstances of this trial.
President, thank you. The floor is now given to the lead co-lawyers for civil parties. You may proceed. Your Honours, we actually can foresee the risk in the trials before this chamber, in particular when it comes to the health of the accused, Nunji and Ieng Sari, which, due to their health, has caused quite delays in the current proceedings. So it is extremely difficult to actually determine a concrete time for the conclusion of the trial. And of course, with the sheer scope of complexity, it is also difficult for the civil parties to prepare ourselves in anticipation of the rescheduling of the hearings in this case. In regards to the scope of the case as determined by the chamber, of course the civil parties support that. But we are unsure at the moment as how much time will the court need to conclude the hearing in case 002/01, taking into account the health and the frailty of the accused. Regardless, we support the scope of the trial as determined by the chamber. And we also support the submission by the co-prosecutors for the extension of the few crime size, and it is up to the discretion of the chamber to balance it. Thank you. President, thank you. Once again, the floor will be given to the co-prosecutors and then the lead co-lawyers to respond to the first question by the chamber. The question is the following. If you maintain your request to expand the scope of case 002/01, is this request limited to the addition of factual allegations related to S21 and District 12? Or do you consider the SCC's direction to ensure reasonable representativity to require a still broader range of factual allegations and charges? Inclusion of S21 and District 12 would encompass only a limited geographical area, encapsulate only a minor part of the overall victimization in case 002, and compel the Chamber to rehear allegations in relation to the only crime site to have been adjudicated before the ECCC to date. The trial chamber limited case 002/01 principally to forced movement on grounds that this phenomenon affected virtually all individuals living in Cambodia during the Democratic Cambodia regime. So please make your comments in relation to the SCC's decisions identified requirement of representativity. You may proceed.
Thank you, Your Honours. I have quite substantial submissions to make to you on this issue because I think it's at the heart of all of this debate. But I would just try and answer some of these questions at the beginning of the question, where I don't actually cover them in my submissions. One particular point I want to address is this issue you raise of rehearing allegations in relation to the only crime site to have been adjudicated before the ECCC to date. And here, let me labour this for the purposes of the public, we're talking about S21 because case 001 dealt with S21 and with Duik. But as far as the proposition that you make that because the evidence relating to that crime site's been heard somehow precludes it being part of the second case, I disagree with that position if that's what's being suggested. The Supreme Court chamber makes it very clear that this court is a sui generis, internationalised court applying international law as well as Cambodian domestic law. And if you look to the guidance of those other courts, of the Yugoslav Tribunal, of the Rwanda Tribunal, you will find that in a number of cases the same crimes were addressed, but in respect of different individuals being tried for the same crimes. An example comes to mind of a case actually that Mr. Karnavas and I were both involved in, which were the events in Srebrenica in July of 1995 in Bosnia. There were multiple trials at the Yugoslav Tribunal concerning events in Srebrenica of different accused. And here, in this instance, we are speaking of people who are more superior to the individual who has been tried and convicted, and thus arguably more responsible for what actually took place at S21. So I want to essentially park that particular point on one side because I don't believe it is something that should be relevant for your consideration, and I think there are other very compelling reasons why you should include S21 within this case. Let me now address you on this issue of representativeness. Now, as I've said, and I'm sorry, I'm trying to avoid repeating myself, but unfortunately this does lend itself to a certain degree of repetition. We seek to have included in this case Tulpul Tray and S21. As far as Tulpul Tray is concerned, we agree with the reasons that you set out in paragraph 3 of your memorandum of the 8th of October of 2012. That's E1635, its connection with the forced transfer. So we agree with that. Now, moving on to this principle of reasonable representativeness when severing. We submit that in the context of an indictment at the ECCC, this is a principle that should be applied, and indeed the Supreme Court chamber directed you to apply it. Now, Rule 89 ter of our own internal rules for this court allows for severance when the interests of justice require it. But that rule does not elaborate on what factors you should actually take into account when you are engaged in the severance process. In such a situation, we submit, in accordance with the agreement and the statute, that you are required to look to international law to guide you. As I've said, the Supreme Court chamber affirmed that approach. They recognised that the severance process requires that the severed indictment be reasonably representative of the full indictment, particularly where there is concern about having more than one case. They held that that approach is directed by common sense, of meaningful justice, and conforms with comparable international legal standards. And in reference to those international standards, you will find that the Supreme Court chamber held at paragraph 42 and, I believe, paragraph 38 of the Supreme Court chamber decision that international standards were reflected in Rule 73 bis D of the ICTY Rules of Procedure and Evidence. Now, I'm not going to read that rule out to save time. I'm sure your legal officers can obtain a copy of it for you. But in summary, what that rule says at the Yugoslav Tribunal is that severance requires that any reduction of counts or crime sites or incidents must be done in a way that what is left in the indictment, in the closing order in our case, is reasonably representative of the full indictment. Now, that rule includes certain factors which should be considered by you in order to ensure that the indictment is reasonably representative. Now, there are 6 factors mentioned in that rule, and there are a further 2 factors that have arisen because of case law at the Yugoslav Tribunal, an additional 2 factors, which I believe will also assist you, and I'll make very brief submissions on them. Now, the first factor that you have to consider are the actual crimes charged in the indictment. What are the crimes charged in the indictment? Secondly, what is the classification of those crimes? Thirdly, the nature of those crimes. Now, you can see that those 3 issues are actually very much linked together. I'll try and unpack them, but they are really, I think, issues that you need to consider together. Now, the 4th issue relates to the places where the crimes are alleged to have been committed. The 5th issue is the scale of the crimes. The 6th is the victims of the crimes. And then a further 2 issues, which, as I say, are incorporated into this matrix by reason of case law, and that's the time period over which the crimes took place. And then the last point, which I think is a very important one in this case, is the fundamental nature or theme of the case. Let's look at the first point, the crimes that have been charged in the closing order. Severance requires that the crimes retained are reasonably representative of the original indictment. Now, the crimes in the severed indictment must be of the same severity and variety as those in the closing order as a whole. And again, I emphasise what I said a moment ago. I believe that you should balance against all of these factors the age and health of the accused. In applying this test, I think you have to do that. That is why we have come up with the formulation that we are going to offer you, because we accept that that is something that you do need to weigh against these factors. Now, the addition of S21 to the annulled severance order, to a new severance order, will significantly increase the representativeness of the indictment in terms of crimes charged. The charges associated with S21 are murder, extermination, enslavement, imprisonment, torture, political persecution, racial persecution, and other inhumane acts through attacks against human dignity. Also, recall, Your Honours, that S21 addresses a number of grave breaches of the Geneva Conventions that we currently don't have in the case as it stood prior to the appeals decision. Willful killing is a grave breach, torture as a grave breach, inhumane treatment as a grave breach, willfully causing great suffering as a grave breach, willfully depriving a prisoner of war to a fair trial, grave breach, unlawful deportation of civilians, grave breach, unlawful confinement of civilians, grave breach. So the inclusion of S21 would lead to the incorporation into this case of 4 additional charges of crimes against humanity: enslavement, imprisonment, torture, and other inhumane acts through attacks on human dignity, and 4 unique grave breaches of the Geneva Conventions: willfully causing great suffering, willfully depriving a prisoner of war to a fair trial, unlawful deportation of civilians, and unlawful confinement of a civilian. Now, it's even arguable that actually, although willful killing as a grave breach addresses murder as a crime against humanity, that there are unique elements within the grave breaches provisions which actually do make it a separate crime. I don't want to split hairs over this, but certainly you can see that if you incorporate S21, you incorporate a whole array of additional charges, providing a greater scope and a much more reasonable representation of the indictment as a whole. Let me look very quickly at classification of crimes, the second factor which this test would offer you to consider in coming to a new severance order. Severance requires that the classification of the crimes charged are reasonably representative of the original indictment. Now, as you know, in the original closing order, those crimes belong to classes: genocide, arguably a very, very serious crime against humanity, but nevertheless a separate provision, crimes against humanity, grave breaches of the Geneva Conventions, and also national crimes under the Cambodian Code of Criminal Procedure. Now, at the moment, we are addressing a single group of crimes, crimes against humanity, including S21, would incorporate grave breaches of the Geneva Conventions. You wouldn't be addressing all of the crimes, all of the different classifications of crimes in the closing order, but you would be addressing substantially more than you are now. Now, the third factor, the nature of the crimes. You must address this too. Severance requires that the nature of the crimes charged are reasonably representative of the original indictment. Again, I know this is linked to the first 2 factors, but I'm giving you the test as you'll find it in the law. Now, the nature of the crimes charged relates to the similarities and differences in the core elements of each crime within a similar class. So, for example, within the category of crimes against humanity, murder and extermination would be similar crimes with similar core elements, because they both, of course, involve unlawful killing. However, murder and extermination would be different to imprisonment, that we don't have, or we didn't have, in the annulled old severance order. As I've said a moment ago, the grave breaches provisions again contain unique elements, one of which is including proof of international armed conflict. So the addition of S21 to the annulled severance order will significantly increase the representativeness of the nature of crimes contained in the closing order. We would be adding to the original severance order crimes of enslavement, torture, including rape, imprisonment and other inhumane acts, willful killing, grave breach, torture, grave breach, inhumane treatment, grave breach, willfully causing great suffering. I won't repeat myself, I've said this already, but you can see that within these other crimes there are unique elements that are not present in the crimes that are currently being addressed by the Chamber. Fourthly, I need to address you on places where crimes were committed. Severance requires that the places where the crimes were committed are reasonably representative of the original indictment. That means that the crimes in the severed case must be geographically reflective of the crimes in the original indictment. So, for example, where crimes occur in the original indictment across a variety of locations within a country, the severed indictment should try as far as possible to reflect that. Conversely, where crimes occur in one place, it would be appropriate to sever the case to exclude crimes outside that one localised place. Now, the addition of S21 to this case would actually significantly increase the representativeness of the places where crimes were committed in the indictment. Now, I know from your memorandum you disagree with that proposition because you say, well, S21 actually was a very limited locus. Now, although S21 was located in one geographical area, it in fact is more reasonably representative of the commission of crimes throughout Cambodia than any other criminal event in the indictment. Why is that? Well, because victims who were tortured and executed within S21 were brought in from all over Cambodia, from every zone, north, south, east and west. And if you read the allegations in the closing order, you will find that it actually supports this proposition. I'm not going to go through all of it, but let me just give you a few examples. If you go to paragraph 431 of the closing order, it states, the CP cadres and members of the RAK who were arrested came from all zones and autonomous sectors of Cambodia. Next, paragraph 434, for the arrest and transfer of CPK cadres and RAK members from autonomous regions or zones, two methods were used. In some cases, S21 personnel would go to the zones and make arrests, or collect prisoners arrested by the zone units and then return to Phnom Penh. In other cases, CPK cadres and RAK members were summoned to Phnom Penh by Office 870, and in particular by Nguyen Chia, officially for a meeting, and they disappeared, never to be seen again. Paragraph 437 of the closing order, the arrest of Vietnamese civilians and soldiers generally took place in the main conflict zone. So you can see that, in fact, contrary to what you say in your memorandum, suggesting that it's very, very limited in geographical scope, in fact, S21 is wide in geographical scope, and it satisfies that particular part of the test. The fifth factor that you've got to consider, which I've mentioned already, is the scale of crimes. Any severance requires that the scale of crimes charged are reasonably representative of the original closing order. This means that crimes in the severed indictment need to reflect the full extent of the original of the crimes in the original indictment or closing order. Now, it's our submission that the addition of S21 in a new severance order will significantly increase the representativeness of the scale of crimes contained in the indictment. What is this case about? This case is principally about the untimely death or murder of between 1.7 and 2.2 million people who perished between 1975 and 1979. S21 better represents the magnitude and severity of the crimes in this case, probably more than any other crime within the closing order. Just a couple of factors for you to consider here. If you look at the closing order, paragraph 422, S21 was the most important security centre in democratic Kampuchea. It was considered to be an organ of the Communist Party of Kampuchea. Its management reported to the highest echelons of the party. It conducted activities on a national scale, and senior-level cadres and important prisoners were held there. We know from the first case that at least 12,272 people perished in S21. A very, very significant number of people, and reflective of the mass killings that went on in this country. The sixth issue that you need to consider are the victims of crimes. This particular factor requires that any new case, any severed case, is reasonably representative of the original indictment in terms of victims, groupings of victims, particular ethnic groups. Now, if you look at the original closing order, the entire population of Cambodia is considered as victims of the crimes charged. Now, in relation to the policy of implementing and defending the CPK socialist revolution through the re-education of bad elements and the killing of enemies both inside and outside the party ranks by whatever means necessary, the victims were from two groups: internal enemies and external enemies. Now, external enemies included, first of all, the Cham, secondly, the Vietnamese, the Buddhists, former officials of the Khmer Republic, including civil servants and former military personnel and their families. Internal party enemies included members of the CPK and the RAK. Now, if you look at the annulled severance order, the victims groups with regard to the first population related exclusively to external party enemies, so city dwellers, new people, and former civil servants. Similarly, if you look at the second population movement, the groups transferred were largely external to the party and the RAK. These groups included, again, former city dwellers, former civil servants, Cham, Khmer Krom, and Chinese. Now, with regard to Tolpol Tray, the victim groups were external party enemies such as former Khmer Republic officials and soldiers, as well as people with bad biographies and viewed to be undisciplined in the cooperatives. In contrast, if you look at S21, the majority of the victims were internal party members of the CPK leadership. This internal enemy group, I think, can be broken down into subgroups, the most significant of which are members of the Revolutionary Army of Kampuchea, with the next most significant being members of the CPK cadres. In both of these groups, the positions of these victims range from the very highest to the lowest within the CPK. More specifically, there were cadres from the ministries for which these accused were principally responsible. For example, 209 victims were from Office 870 and S71, and at least 113 were from the Ministry of Foreign Affairs and 482 from the Ministry of Commerce. These victims came from across the entire country, and the influx and type of prisoners directly related to the purges conducted around the country. Other groups which were not CPK cadre or RAK military were former soldiers and officials of the Khmer Republic, former members of the National United Front of Kampuchea, members of the educated classes, teachers, professors, students, doctors, lawyers, and engineers. Of the non-Cambodian victim groups at S21, the Vietnamese were in the largest of the subgroups, with also people from Thailand, Laos, India, and Western countries, United States, Australia, and United Kingdom. So it's absolutely apparent that if you include S21, you increase the victim groups that will be represented, the people that will find justice. They've gone, but justice can still be done for a wider group of victims. Let me talk about the last two factors that you need to consider. First of all, the time period of the crimes. Now, although this is a factor that's not explicitly recognised under ICTY Rule 73 bis D, case law at the tribunals has emerged that severance should ensure that the time period of the crimes charged are reasonably representative of the original indictment. For example, a severed indictment should be reasonably representative of the months or years over which the crimes took place. And second, a severed case should try and reflect, as far as possible, any key phases in the commission of those crimes. And the case which supports that proposition is the prosecutor and Stanisic and Simatovic, Stanic, Simatovic, Simatovic, case IT 0369PT, decision pursuant to 73 bis D of the Rules of Procedure and Evidence, and I'll give the date of that decision. It is the date of that decision for the purposes of reference is the 4th of February 2008. Paragraph 23 is the relevant part of that judgment. Now, the addition of S21 to this case will significantly increase the representativeness of the time period. In contrast to the forced transfer, which, as the trial chamber has pointed out, occurred right at the beginning of the chronology of this terrible story, it's very, very limited. It's a limited period of time. Now, S21 became operational in October of 1975 and remained in operation until the 7th of January 1979. So you would, in effect, be covering the entire time period of the closing order by incorporating S21 into the case. Now, the last issue to consider, again, this was also introduced by case law from the ad hoc tribunals. Again, it's not a factor that's explicitly recognised within 73 bis D, but chambers have incorporated this particular factor in the matrix that they use to decide on how a case should be severed. And they say that severance should reasonably represent the fundamental nature or theme of the case. Now, you can find the law on this in the Stanisic and Simatovic decision, which I mentioned, at paragraphs 8 and 9, essentially supporting this part of the test. The addition, Your Honours, of S21 really reflects the heart of this case. If you look at the common purpose of the joint criminal enterprise, it states that the common purpose was to implement rapid socialist revolution in Cambodia through a great leap forward and defend the party against internal and external enemies by whatever means necessary. Now, that common purpose is said to have come into effect on the 17th of April of 1975 and continued until the 6th of January of 1979. Now, as things stood in the now annulled severance order, we were addressing principally the forced movement of the population, only one of 5 criminal policies identified as being part of the joint criminal enterprise in the closing order at paragraph 157. By including S21, you are not only covering the entire period of the joint criminal enterprise, but you will also be addressing 3 of the 5 criminal policies expressed in the joint criminal enterprise within the closing order. In conclusion on this issue of representativeness, this case, the heart of this case, although there were multiple types of crimes that were committed during this period of time, but the heart of this case is about arrests, torture and murder at security centres. The accused have been charged in respect of 11 security centres. S21 is one of those security centres directly connected to the Standing Committee. Directly connected to the Standing Committee, an important factor bearing in mind the accused that we are dealing with. So, in conclusion, Your Honours, and let me just check that I've actually answered all of your questions, I would emphasise that contrary to what you say here, in fact, the inclusion of S21, we're not now asking for District 12 because we have gone through this balancing act of looking at the health and fitness of the accused, and we're not now pursuing that any longer. But we do believe that S21, in fact, represents a very large proportion of the types of victims who suffered in this country. And we do believe that it encompasses, for the reasons I won't repeat, a significant geographical area, because victims came from all over Cambodia. And I think I've covered in some depth this concept of representativity, which the Supreme Court chamber directed your minds to address when you make your next decision. So thank you, Your Honours. I don't have any further comments.
The President, thank you. Next, I hand over to the lead co-lawyers for the civil party to respond to this question. Counsel Pich-ong. Thank you, Mr. President. Actually, I do not have much thing to add. We simply concur with the International Co-Prosecutor concerning a schedule that is quite comprehensive, and I think that the point should be well taken. As a matter of fact, the civil parties, lawyers representing the civil parties who have endured a lot of atrocities, including the Cambodian national Cham, Muslim Chams, and Vietnamese minorities in Cambodia, suffer from the atrocities and crimes committed during the period of 3 years, 8 months, and 20 days. And on behalf of the civil parties, we do want the trial chamber to adjudicate on those crimes allegedly committed during the period. However, taking into account the actual circumstance, we also understand that if the scope and magnitude of the case is not manageable within an appropriate period of time, we would ask the chamber to consider appropriate scale down of the scope. And as for the proposed inclusion of crime size in S21, I think that it is very appropriate. And of course, if you look at the prisoners who were detained and tortured at S21, some of our living civil parties and witnesses are also were also imprisoned in S21, and they are now also the civil parties to the proceedings, and they are demanding that the justice be brought to them. So I believe that the scope of S21 is appropriate to be included. The President. The time is now appropriate for lunch adjournment. The Chamber will adjourn now until 1:30 this afternoon. The Court is now adjourned.
សូមក្រោកឈរ